Mr. Clerk.
Item 10 is an ordinance presented by the City Attorney with a recommendation to receive public input and discuss the draft ordinance regarding medical marijuana.
Thank you. Mr. City Attorney is going to do the staff report on this. Mr. Shannon, please.
Mr. Vice Mayor, do you realize that we'd be out of here by 6 o'clock if it wasn't for this item?
I'll take a motion to set this aside.
Mr. Vice Mayor, City Council, ladies and gentlemen, you have before you for public comment and for your consideration a draft ordinance relating to the regulation of medical marijuana. Before summarizing the ordinance, I want to briefly provide some background, and that background is largely set forth in our report dated October 22nd, 2009, which was provided to the Mayor and to the City Council. Our analysis begins with the fact that under both federal and state law, marijuana is a controlled substance subject to criminal regulation and prosecution. What I'd like to do, though, is for the moment put aside the federal law, because frankly, the inconsistencies between state and federal law have confused the issue. So we'll confine ourselves to a consideration of the full universe of relevant state law. Under state law, specifically the California Uniform Controlled Substances Act, marijuana is deemed to be a controlled substance for which possession for sale, cultivation, distribution, transportation, and maintenance of places used for storage or distribution of marijuana are criminal offenses. Therefore, the rule is that these activities with regard to marijuana are state criminal offenses unless other legislation provides a defense from criminal prosecution. That brings us to the legislation that provides a defense under certain circumstances. We start with the California Compassionate Use Act. In 1996, voters enacted Proposition 15, which by its terms ensured that seriously ill Californians have the right to obtain and use marijuana for medical purposes where the medical use is deemed appropriate and has been recommended by a physician who has determined that the person's health would benefit from the use of marijuana in the treatment of cancer, anorexia, AIDS, chronic pain, spasticity, glaucoma, arthritis, migraine, and any other illness for which marijuana provides relief. A qualified patient and their primary caregiver who obtain and use marijuana for medical purposes upon the recommendation of a physician is not subject or are not subject to criminal prosecution or sanction. However, the Compassionate Use Act did not establish an absolute immunity from arrest or prosecution. What it did provide was a limited defense which may be raised by qualified patients, as that term is defined, quote unquote, and designated primary caregivers, quote unquote, to protect against criminal conviction for marijuana possession and cultivation. Since in some quarters it was deemed that this particular initiative was unclear, the legislature enacted a second piece of legislation, the California Medical Marijuana Program Act. This was in 2003. The MMP expanded and clarified the scope of the CUA by establishing guidelines for a voluntary medical marijuana identification card issuance and registry program for patients and primary caregivers, articulated quantities of marijuana that patients and primary caregivers can presumptively possess, provided affirmative defenses for qualified patients and primary caregivers who associate as members of a legally recognized cooperative in order to collectively and cooperatively cultivate medical marijuana for the use of its members, and 4, identify locations and circumstances wherein medical marijuana is prohibited. However, quote, nothing in the law authorizes any individual or group to cultivate or distribute marijuana for profit. The fundamental provision of the MMP, and I quote it as follows, is, quote, qualified patients, persons with valid identification cards, and the designated primary caregivers of qualified patients and persons with identification cards who associate within the state of California in order collectively or cooperatively to cultivate marijuana for medical purposes shall not, solely on the basis of that fact, be subject to state criminal prosecution or criminal sanctions. That said, again, MMP made clear that collectives, cooperatives, and other groups shall not cultivate or distribute marijuana for profit. Collectives and cooperatives comporting with state law are distinguished from storefront dispensaries selling marijuana over the counter, which are not protected by the MMP. Currently, bona fide medical marijuana collectives and cooperatives are limited to cooperative cultivation of medical marijuana, which may be distributed solely to its members. The MMP does not protect against the sale of marijuana cultivated by the collective or cooperative to members or non-members, distribution of marijuana cultivated by the collective or cooperative to non-members, or distribution and or sale of marijuana not cultivated by the collective or cooperative to members or non-members. It was noted in my report, and it's very significant, that the Los Angeles County District Attorney Steve Cooley announced that all medical marijuana dispensaries selling marijuana in Los Angeles County are illegal, and they are, quote, going to be prosecuted. My report goes on to discuss the California Supreme Court case of People versus Mensch in some detail, and I won't repeat that here, except to again indicate that and to emphasize that, according to Mensch, no ordinance may purport to regulate over-the-counter for-profit sales of marijuana, since the Supreme Court in Mensch has determined that they may not legally operate. Finally, the MMP encourages local regulations. Quote, nothing in this article shall prevent a city or other local governing body from adopting and enforcing laws consistent with this article. In fact, many local entities have enacted local regulations, including outright bans. We've studied those other communities. I believe there are a number of them. We've studied at least 20. I understand, based upon an article that we recently read, that 8 counties have banned dispensaries outright. Now, my report goes on to indicate a list, a non-exclusive list of permissible regulations. It's contained at page 6. And now I would ask Deputy City Attorney Crystal Meyer to outline the provisions of our draft ordinance.